I hope everybody can read the the Wi-Fi password and username. Otherwise, for you to log on, it is conference and the password is ICMIS at 24. You will be straight there. Okay. Those are some of the wonderful innovations the judiciary is bringing. When you come to the judiciary, feel free to use the goodies that we have come up with. Enjoy. Yes. Yes. So these are the wonderful products of your support to the judiciary. So why not? See, I can see Council Shandia enjoying. Please just log on. It is free. We shall not charge you. I can see Dr. We shall not charge you. Don't expect a fee note from us. Yes. We want you to feel at home. You see, you can even now Google that wonderful commentary somewhere in the Commonwealth about the bar bench so that we can share that information here when we start the meeting. So enjoy yourselves. This is the judiciary. The chief registrar is also with us. Yes. The chief registrar is with us. And so anytime we shall be joined by the Honorable Principal Judge. And see on Senior Counsel Kavega coming in. We are happy to have you this afternoon. Yes, can we pull down this program? ICT, please let us pull down the program and we edit it. We shall be editing it. Our beloved advocates in the house, may I have your attention? Advocates in the house, there is a QR code on at the tables. Please, it's very helpful. Please scan it and forward it. There are very important points, CLE points that will be earned from just taking and scanning this QR code. And our online members, we definitely know that there is a mechanism also for capturing your attendance. But there is this QR code, please, it's on all the tables. If it's missing where you are and you're an advocate, please, we can, somebody behind there is able to come close and you get the same. Yes, I have been reminded that when people come for meetings like these, they have expectations. And probably we could take off time as we wait for a convener. If you can share with us some wonderful expectations so that we can see how to meet them. It's a very wonderful moment when we have you honorable judges, senior advocates, and all other advocates in private practice, as well as in the academia, amidst us, to share in this bar bench meeting. But we recognize that wonderful mind of expectations. If we can share some, we are happier to record them and we pass them on so that at the end of the meeting, we should evaluate to know whether we have served your expectation. We have a microphone that will pass around just in case you want to share with us. Let me request my brother to come close so that you feel comfortable to share with us. I know Councillor Chandia usually shares very wonderful insights. And now that you are seated next to my brother Mchivi, you should be the first people to throw in and we capture that one. Please, you go close. I know those are people I know. My teacher, JMM, you know, and of course, Makerere University, those are the brains we want to hear from this afternoon so that we are able to start rolling wonderfully. Yes.
Thank you, Your Worship. Our MC, all protocol observed. My name is Paul Mchivi from LDC and ULS. I'm happy to be here. And one of my expectations is to hear the plan we have for Luwero High Court. As I talk now, we have received the memo adjourning cases to next year. I last got a date in court last year, and the matter was adjourned in March this year. In March, there was no business, adjourned to November. Before November, a memo has come, matter is adjourned until next year. So I'm here to see what plan we have. What I tell a litigant, the case is not heard for 2 years in the system.
Wonderful. Thank you very much. At least we are on board. Yes, at least we know how to go through this engagement. Yes, Councillor Chandia. Yes, he has passed it on to Senior Counsel JMM. Okay, it's okay. It's very wonderful. Yes. It's very good. You can pass on to the next.
Thank you, MC. Good afternoon, my lords, ladies and gentlemen. I recall when we last had a bar bench meeting, we raised concerns regarding case backlog, regarding migration from ECMIS, rather to ECMIS, from the way matters were being handled, regarding contradictions which were raised, especially within the judiciary, the respect for the doctrine of precedence and the stare decisis, and regarding uncertainty.
We have the Honorable Principal Judge. My Lord, you are most welcome. And my Lord, as you stepped in, we were listening to very wonderful expectations that the members here would want met at the end of this engagement. And with your permission, I will allow Senior Counsel to complete with that expectation, and we proceed, my Lord.
Much obliged. So I was saying that members, especially the legal fraternity, had raised concern regarding inconsistency and unpredictability regarding the fixture of cases, and as far as the relationship between the bench and bar regarding the decorum, mutual respect, and then the respect between the senior bar and the junior bar. So I expect by the end of this meeting, we shall have taken stock, looked at the metrics which we prepared, and see how far we've traveled. I'm obliged.
Oh, thank you very much. And now that the Honorable Principal Judge is here, I think those expectations were quite accommodative of even all others. My Lord, we want to welcome you to this afternoon meeting, and we have a small agenda which shall comprise of a prayer. Thereafter, we shall have welcome remarks from the Honorable Chief Registrar, followed by remarks from the representative of the President, Uganda Law Society. And then, my Lord, we shall also have remarks from the representative or delegate sent from the Office of the Attorney General. And then, my Lord, we shall have concerns by members, after which, my Lord, we shall have your responses, and then you make your final remarks, my Lord. It shall be an interactive engagement. My Lord, you shall feel free to adjust with this program so that we can have the full engagement of members. We also have, my Lord, online participants whom I would like, my Lord, to welcome to this engagement. And with your permission, two expectations which are real broad were raised by members. One of them is that the bar would like to hear if there are any plans for Luwero High Court in light of adjournments that are stretching as early as next year from now. And I believe, my Lord, this cuts across other jurisdictions, but generally that's the situation. And then also the follow-up action plans since the last bar bench meeting where issues of case backlog were raised, migration to ECMIS, and then several contradictions within the relationships between the judiciary and other organs of state, and also the firm recommendations about enhancing and improving decorum and respect within the legal profession. My Lord, allow me invite Worship Geneva Natukunda to lead us into an opening prayer. Your worship, please.
my lords and all invited guests, let's humble ourselves for prayer. Heavenly Father, we thank you for the gift of life. We thank you, Lord, for the love you have bestowed and your grace and mercy upon everyone here, for the journey mercies up to here. Heavenly Father, as we gather here, we pray that your Spirit, Holy Spirit, help and give us wisdom to discuss so many issues which have been raised, expectations which are in our heads, those which have been aired and those which are yet to be aired and discussed, that we are able to have resolutions, that we are able to have ideas, that we are able to have interactions, that we are able to have deliberations, because we know that all of us, our vision is justice for all. I pray all this in the mighty name of Jesus Christ.
Thank you for that prayer, your worship. My Lord, Honorable the Principal Judge, your worship, the Chief Registrar, the representative of the Attorney General present, my lords in the House, Senior Counsel, your worships, and all other invited guests, you are most welcome. My Lord, allow me to recognize and introduce to you the members in the House. And my Lord, on your immediate left is the Chief Registrar, our worship, Saralanga Siu. You're most welcome to joining us. And my Lord, on your immediate right is the representative of the Honorable Deputy Attorney General, Mr. Mwangusia Martin, who is the Director of Civil Litigation. You're most welcome to this gathering. My Lord, we have Mr. Martin Asingwire, the Vice President of the Uganda Law Society, and is here, my Lord, to represent the President, Uganda Law Society. In the House, my Lord, we have the judges who have come to join this meeting. And allow me, my Lord, to introduce to you Honorable Justice John Eudes Ketrima, the head of the Family Division. My Lord, you are most welcome. We also, amidst us, we have Honorable Justice Stephen Mubiru. My Lord, you are most welcome. The head of the Commercial Court. And my Lord, we also have a Lordship, Lady Justice Susan Okalani. My Lord, you're most welcome. We also have the Deputy Head International Crimes Division. We have Honorable Mr. Justice Musa Sekana, the Head Civil Division. You're most welcome, my Lord. We have Senior Counsel. We have Mr. JMM Mungisha, you are most welcome. We also have very renowned senior criminal lawyer. If you want to, my Lord, to understand criminal law out there, they would always want to run to that wonderful gentleman. And he's also a very interesting person, my Lord, at least I know from the outside. He loves motor racing. That is Counsel Kavega. Yes. We also have our wonderful from the academia and from Makerere University. We have, I forget the name, my apologies. You are most welcome. Okay. May I request the registrars present, please stand up for recognition if you are registrars. Okay, some are seated this other side. We also have chief magistrates and magistrates grade ones. Please, will you stand up for recognition? Okay, and then we have other advocates. The rest of the advocates present, please stand up for recognition. I will not ask Chandia to stand up, but at least you can put up your hand. Yes, thank you very much for coming. My Lord, we have several participants online, and we want to welcome them to this meeting. You are all most welcome. And with those recognitions, I will recognize others as we come in, my Lord. Allow me welcome the Chief Registrar to make her welcome remarks. Your Worship, you're welcome.
Thank you very much, Your Worship, the PRO. My Lord, the Honorable, the Principal Judge, my Lords, the judges present, the representative of the Honorable Attorney General, and the representative of the President of the Law Society. Allow me, my Lord PJ, to stand on the protocol that has been laid out by the PRO. Mine is simple this afternoon, my lords and members of the bar, together with all their worships and members present here on online. I wish to take this opportunity to very warmly welcome you for this very, very important engagement. And I take the honor to thank the Honorable, the Principal Judge, for initiating and convening this very much needed engagement. It's like we've chosen to be a bit dull this afternoon, but I would request that we clap for the Honorable, the Principal Judge, who has convened us, because even if we have issues, we can still be happy and share them with a more joyful heart. My Lord, PJ, this is an important forum which you are spearheading in the judiciary to ensure that we have the opportunity to talk to the different stakeholders and resolve the justice needs that we have in our different courts. Indeed, expectations are coming out, and some are coming from the meeting that we last held of this kind on the 21st of February. But I wish to inform members that the Bar Bench Committee has been set officially in the judiciary. And so this is going to be a continuous engagement between the judiciary and members of the bar. And this is not going to end here. It is going to trickle down up to the lowest court that we have in the judiciary. So the Bar Bench Committee stems out of the broader Case Management Committee of the judiciary, which was appointed by the Honorable the Chief Justice. And these committees are a creature of the administration of the judiciary establishment of committees regulations of 2023. Now, those regulations provide for the different committees of the judiciary, case management being one of them. And under the Case Management Committee, there are different subcommittees that are all working towards the greater goal of enhancing case management, improving case disposal, and resultantly fighting case backlog that has been with us for a long time. So in addition to Bar Bench, you will be having division court user committees. And it is our hope that also before this quarter ends on the 30th of September or early October, the divisions in Kampala should have held these meetings with their users, you the advocates, but also other stakeholders, so that you're able to generate solutions to some of the local problems within the different jurisdictions. In addition to the division court users, for those who practice in the circuits, there are also the circuit coordination committees. which will be bringing together the resident judges, the practitioners, and other justice actors in the circuits to be able again to discuss the different justice needs and see how to find solutions to the problems. At the magistrates level, we shall have the district coordination committees, which will be spearheaded by the different chief magistrates who are manning the magisterial areas in the different districts across the country. And all these platforms will be able to help them have discussions like what we are going to have here today, but intentionally to have solutions for the local problems in the courts. So as we have this engagement, my appeal is that let us be as candid, but certainly as respectful as we can be. And one of the challenges I keep getting, and I have had this engagement before with some of the members of the executive of the Law Society, is blanket complaints. Sometimes somebody is talking about absenteeism, but other than identify the court, it is given as a blanket and it makes follow-up very difficult. We've had engagements with the president of the Law Society and some members of the executive. And sometimes we've talked about social media complaints. You find an advocate says, you know, I went to court X and there was nobody. So immediately we pick it and say, Inspector of Courts, can you follow this? And then the inspector gets frustrated when the advocate cannot be able to open up and say, this is the court that I was talking about. So while we want a better judiciary, while we want better administration of justice, the point for us is that we are working together and we can only provide solutions together. So in instances where there are complaints, it is nice to bring them on board. And I want to thank Mr. Muchibi, who has started by laying the point as it is from where it is. Otherwise, if he said there is a court where their matters adjourned to next year, it would be difficult to address the problem. Certainly, there are matters we are happy to also receive in confidence. So my call to some of you here is that if the matter cannot be raised here, do not hesitate to knock at our doors. We have the Inspector of Courts here who can be able to handle some of these matters, and then you find solutions. As we go along, we are going to talk about how far we have gone in implementing the issues that were raised at the last bar bench. And so, Mr. JMM, we shall be able to talk about what have we done to address backlog, or what are we doing to handle the different matters that were raised, the numerous adjournments, the actual, the perceived corruption, what is happening. We shall be able to have that engagement. With that, I want to thank you all once again for coming. I warmly welcome you once again and wish all of us very fruitful deliberations. Thank you very much.
Another applause for the Chief Registrar. And thank you for assuring our members that all those concerns are going to be responded to. My Lord, Principal Judge, allow me invite the representative of the President of Uganda Law Society to come and make his remarks. I most welcome Mr. Martin Singwiri.
My Lord, the Principal Judge, Your Worship, the Chief Registrar, my Lords, Judges of the High Court present today, representative of the Attorney General, my colleagues, the Senior Counsel, the senior members of the bar, ladies and gentlemen. I was excited to hear that today it's going to be more of an interaction. So I'm also going to try and keep it in those limits without trying to give a speech. My Lord, the Law Society is particularly happy and excited that we are having these forums and that we are having them routinely, and that we can have a place where we can come and discuss the issues that are affecting the practice of us, the lawyers and administration of justice in general. I'm also happy for the attendance of today. I'm happy that I'm seeing a lot of advocates today here. So I'll try not to raise the complaints myself and reserve most of the time, giving them a chance so that they can tell you what is at their heart and what is affecting them. There is definitely quite a number of issues that are becoming a blockage in the practice of advocates. Majority of them have been discussed in several bar bench forums. And my Lord, I'll start by saying that we need to keep track of the discussions that we have. We have a bar bench forum today. The members will raise their concerns and we'll discuss them. Some solutions will be found and some solutions will remain to be found. But how do we track these resolutions? How do we track these discussions? We have our bar bench forums in upcountry courts. I personally practice majorly from Ginger. We also have our bar bench meetings. One of the issues I always raise every time I'm invited to them is that there is no track record of what we've discussed before. We can discuss the issue, for example, of missing files in January. We will discuss the issue in May. We will discuss the issue of missing files in September. Business continues as usual. Then it becomes more of ticking in the boxes rather than finding the solutions. That is something that we must look into, that when we have openly discussed these issues, that they will be resolved. It's very possible that an issue affecting advocates here in Kampala is already affecting advocates in another place. My Lord, there is the issue of raising complaints. Bar bench meetings shouldn't be a place where we only come to raise complaints. There should be already a known and well-established system of, let's say, whistleblowing. Just today, my Lord, on one of our forums, we were discussing a certain judgment that came from Gulu High Court. Pardon me for saying, but this is now on record. A certain litigant wanted a certain judge beheaded for dismissing his cases. He brought case after case, and they seemingly were baseless complaints. But what do you tell this litigant besides listening to their case? Do we tell them that if you want to complain against a judicial officer for the decision they have made, this is the place that you go to? There is the Inspectorate of Courts. So the institutions are there, but what is missing? If the complaints are not coming in the way they're supposed to come in, if the advocates are not raising the complaints with the specifics of what is happening and where and when, then there is an issue for discussion. How do we bridge that gap? How do I, as Singwire, for example, bring a complaint to you without telling you that I'm a Singwire? Because advocates will not want to expose themselves to any bias. They have matters in and out. It's like how we deal with police. Today you're begging them to give you bond. The other day you're begging them to have another person arrested. How do we bridge that gap? Whistleblowing is a very, very critical issue when you want to get complete views that are detailed enough to enable you to do the investigations. My Lord, I also wish to state that I'm happy with how some of the complaints, I have noticed that, my Lord, whenever complaints come to your desk, you have sent majority of them back to the senior resident judges in those stations. I know that for us as advocates, we will try and raise those complaints before in those courts, in those circuits, before we bring them to you. But there should be, I think, a clearer system in which we know that we can raise complaints. My Lord, I can assure you that lawyers will write, they will complain, they will identify the issues. out of 100 letters written to a judicial officer over their matters, I think if we are lucky, we'll only get some notes written on that letter and sent back to the registry. The lawyers are not getting feedback on their complaints. I don't know how many lawyers have ever gotten a letter from a judicial officer saying, in response to the letter you wrote to me, this is what I have done, or this is what I'm planning on doing. So it's very important that when they are raised, there is a track record of how they are handled, and that the people raising these complaints or these issues get the proper feedback. My Lord, on the overall, I know that issues concerning ECMIS have been touched and will be raised, but it is also important. ECMIS, I think, first and foremost, Professor Muchibi, I think when you get a chance, you'll expound this. The most important part of introducing ECMIS was to make administration of these matters seamless. If a lawyer's work is to litigate a matter, a lawyer should not spend 80% of their time doing the administrative part of the issue. And I think that's why also the backlog remains an issue. If administration still becomes a stumbling block in a lawyer's practice, the lawyer does not get to argue the actual point or is too exhausted about a certain matter. I'll give an example of hearing notices, for example. My Lord, there will be court registries where to get a hearing date, you need to write a letter and you need to attach a hearing notice, and then you need to follow up. Not too long ago, I was opposing a bill of costs in Fort Portal. This lawyer had billed 1 million shillings to go to court to extract an order before a magistrate grade 1. And he billed another 1 million shillings to go and follow up to see if the order was signed. When you create that kind of interface in just the part of administration and not exactly hearing these matters, there are bound to be delays, there are bound to be frustrations, and there are bound to be biases. I will be very excited when I see ECMIS rolled out so that clients don't have to pay 1 million shillings. I actually pointed it out that even orders in a magistrate's court are actually supposed to be extracted by the judicial office. The lawyer did not know that that's how it works. The judicial officer did not know. He literally told me, no, counsel, we can't do your work. If we make it seamless and we focus on the actual dispute, we will get where we're going. My Lord, the Uganda Law Society is about to go into elections. I know that there are fears from the side of judiciary that the lawyers may not do the right thing. Some of those fears were reflected in when they were writing the agenda. They removed the A in the law and they put an O. I don't think we should be worried. The Law Society is not going that low. I think we can be trusted that we shall choose our leaders, and we should keep the faith. Whichever leader the Law Society chooses, the Law Society works by a council, and the bridges will not be burnt. The fears, most of them, I can promise, are perceived. The society will choose its leaders, will continue this good working relationship and collaboration, and we'll all achieve what we are set to achieve. Allow me to end here to allow enough time for the members to raise these issues. And thank you once again, my Lord, for this opportunity, and wish everyone here fruitful deliberations. Thank you very much.
Let us give the president another applause. And my Lord, allow me to apologize to the Uganda Law Society that the law in law was just a typo We did not intend to to say that it is the Uganda Law Society. It is actually the Uganda Law Society. Most obliged. And thank you very much for those points. And I want to assure you that the judiciary, we are not worried. We can't get worried. Yes. My Lord, allow me invite the representative of the Honorable Attorney General to come and make his remarks. You're most welcome.
Thank you, Your Worship, and also mainly for correcting that other clerical error that the Law Society is. We are all worried, but we thank you that we are back on track. My Lord, the Principal Judge, my Lords, the judges of the High Court, Your Worship, the Chief Registrar and all the judicial officers present, the Vice President of the Uganda Law Society, government officials present, the advocates and all lawyers present, ladies and gentlemen. I'm here to really bring the remarks of the Honorable Attorney General. So I don't want to hold out that I'm the Attorney General. I am not. My name is Martin Mwambusia, and I work with the Chambers of the Attorney General as the Director of Civil Litigation. But before I go into these remarks, I just wanted to just say a few things just on a personal note. I did attend the last bar bench, and I thank God I'm attending this one. I think this kind of engagement has really brought in quite a number of positive aspects. And as we are here, let's not forget to take stock of the good things. So let's also give these judges the flowers that they should get. Otherwise, we'll all keep here, keep lamenting. Where I work, if you lose a case, everyone is coming for you, not even knowing that it's the client who participated. It is your job, you're supposed to win cases. Yeah? So, but I think it's always right to always really give people their flowers when they are still there. So these are the remarks from the Attorney General. I'll read them verbatim. That I would like to take this singular opportunity to thank the Judiciary and the Chief Justice in particular for organizing the bar bench meeting today. That this kind of meeting is essential and necessary to ensure that the bar and bench share and discuss challenges facing each other in their working relationship and enable the improvement in service delivery to the court users. This interaction helps the bar and bench to be open to each other since both professions are all striving for justice for the people of Uganda. The work of the advocates and judicial officers are complementary as they are players in the same field, that is the field of delivering justice. And this explains why advocates are called officers of the court. We are all aware that justice is delivered in the name of the people as per Article 126(1) of our Constitution, which provides that judicial power is delivered from the people and shall be exercised by the courts established under this Constitution in the name of the people and with the values, norms, and aspirations of the people. In addition, Article 126(2), which provides that in adjudicating cases of both a civil and criminal nature, the courts shall, subject to the law, apply the following principles. A, justice shall be done to all irrespective of their social or economic status. B, justice shall not be delayed. C, adequate compensation shall be awarded to victims of wrongs. D, reconciliation between parties shall be promoted. And lastly, E, that substantive justice shall be administered without undue regard to technicalities. So considering that the role of advocates and judicial officers are complementary, this kind of engagement is essential to ensure a smooth relationship between the bar and the bench, so that any challenges and issues that affect their working relationship and by extension, the delivery of justice is spoken about openly and in good faith and resolved in the interest of justice. It is therefore necessary for the advocates and judicial officers to speak to each other and both understand or should understand that they have a responsibility to the public. An opportunity like this is thus necessary to discuss matters that affect both the bar and the bench concerning their working together. Therefore, we are happy to be a part of this bar bench meeting today. And as the Attorney General's chambers, as you know, we are probably the biggest court users in Uganda, at least going by the number of cases that are filed against the Attorney General in the courts. These are the issues I would like to raise today. That of late, we have noted with concern that there are some advocates who have resorted to resolve their complaints against judicial officers through or on the social media. We do not think that that is the right way to resolve complaints against the judicial officer or advocates for that matter. The legal profession is a noble profession, and I think it is better to resolve the disagreement with judicial officers through the known procedures and the channels under the law, and administratively through the complaints to the head of the judiciary, the Chief Justice, the Principal Judge, the Chief Registrar, or the Inspector of Courts. We need to continue to have respect for each other between the bar and the bench, since all of us are interested, or at least should be interested, in justice. Justice is the common nomenclature that should enable us work together respectfully. We still have the challenge of delay in delivery of justice. Cases still take long to be concluded. Both the advocates and judicial officers are culpable in this delay. Some lawyers have specialized in seeking adjournments and not implementing the directions of court in the timeframes given, leading to delays in concluding cases. We need to be mindful that justice delayed is justice denied, and is a very real issue for a person who, for example, sued for recovery of their land, breach of contract, and continue to lose money, or a victim of a crime. The judicial officers need to continue to improve on the timelines for delivery of their decisions. There is still concern around ethics at all levels. The government improved the terms and conditions of service of judicial officers recently. It is therefore critical that the judiciary addresses the concerns around corruption that still hangs around the neck of the judiciary, perceived or real. Advocates too are not to be allowed to go scot-free in this vice, going the complaints before the Law Council against advocates. As a noble profession, we need to fight against this vice if we are to claim our position in the Ugandan society. We still have a challenge of case backlog in courts. We recommend the government for provision of resources that has enabled the judiciary to expand its presence to the population, and the judiciary for deploying judicial officers further down among the population, thereby taking judiciary services closer to the people. However, the judiciary now needs to get to serious work and address the issue of backlog. There are also concerns around the quality of decisions of courts, both in depth and validity. The lawyers too are having challenges of drafting proper pleadings. It is important that both the bar and the bench address this challenge. This calls for continued training of both judicial officers and advocates. Most lawyers are only eager to get points for renewal of their practicing certificates instead of actually improving their skills through training. Payment for courses organized by the Uganda Law Society should mean something rather than just points for the purpose of renewal of practicing certificates. We appreciate the judiciary for the innovations that have been made in the delivery of justice, especially in the areas of ICT and small claims procedures. Filing of pleadings online is easing work for advocates. You can imagine the movement our office, that is the Attorney General's office, had been undertaking where we were filing physically. We encourage the judiciary to expand this to all high court circuits if resources do allow. With these few remarks, I encourage the bar and the bench to continue having this kind of engagement, and also take the comments and criticisms from either side in good faith and ultimately ensure justice for all. Thank you very much for listening to me. Not Martin Mwambusia.
Yeah, thank you for being a good messenger. My Lord, at least it is not all lost, because at least the head of the bar has said we deserve flowers. Please, another applause. When we are out there, my Lord, you always think like everything is bad, but at least this is quite very rejuvenating. My Lord, I would like to invite you to make your remarks. Therefrom, then we shall have the concerns from the members. Most welcome, my Lord.
The Honorable Attorney General, who is represented by the Commissioner of Civil Litigation. My Lords, the judges present, maybe let me adopt the protocol, which I'm sure the PRO outlined properly. I must apologize for coming in a bit late. I was in a Zoom meeting with one of the donors, so it took a little bit longer, but I was not too late nevertheless. I always keep time. I greet you all, and I welcome you all to this meeting, both those attending physically and online. This meeting is intended, number one, streamline the relationship between the bar and the bench. You know, both sides are not angels. You know, when we come here, the lawyers blame the judges blame the lawyers. So this meeting is actually intended to, to streamline our relationship, which actually should be that way. Perhaps we tend to forget that we are all officers of court. And sometimes when I see, some advocates trying to, to discredit the profession, it's like cutting your own banana plantation. This is our profession. That's where we earn. In the eyes of the public, we need to protect it. And when we come here, we undress ourselves. But in the eyes of the public, we need to protect this profession because it's our garden. We are supposed to eliminate mutual mistrust. That's the purpose of this meeting. Thirdly, we are supposed to bring out the challenges the bar is facing in the pursuit of administration of justice, and we agree on solutions. Number four, we are supposed to find ways and means of revamping confidence in the administration of justice and the legal profession as a whole. I believe that we should nurture a tradition of continuous engagement through this and other forums, and this is from the growing culture of washing our dirty linen in public. This fosters growth of an independent and honest bench and a strong and vibrant bar. In the last meeting, apparently I missed the last engagement, but the previous one, I had raised the concern of breaching the sub judice rule. However, some advocates continue breaching the sub judice rule. I wish to further bring to your attention Regulation 20 of the Advocates Professional Conduct Regulations, which states as follows, and I quote, "An advocate shall not make announcements or comments to newspapers or any other news media including radio and television, concerning any pending, anticipated, or current litigation in which he or she is or is not involved, whether in a professional or personal capacity. Now, this is in our conduct regulations. But you see, I've seen when I'm watching news, then, after a session, then advocate comes up, the cameras are surrounding him. What do you think? I'm telling you, we are winning this case. The judge has no choice but to, sure, comrades, I was an advocate myself for a very long time before I came to the bench. And I'm sure that you cannot say you will win until you win. Now, so why do we breach this? I know some of you, you are trying to attract some little bit of attention, but you don't have to do that. I mean, I know the senior lawyers here who are very good, and I have never seen them doing that. But are they not getting clients? I think sometimes we don't have to breach the law in order for us to. So there are some advocates who have continued to prosecute all their cases in the media. This is wrong and breach of the law. The sub judice rule serves four purposes. Number one, to avoid prejudicing forgive the fair trial of an issue. You see, sometimes whatever you say, people can easily condemn the person before the matter is concluded. Number two, to preserve the impartiality of the judicial system. Now, you see, I've seen in situations where lawyers go out there and then say, we are going to win. And then these journalists they ask the people who are the bystanders, what do you think? I'm telling you, the bystanders also become advocates. Yeah, so that's the danger. Three, to prevent the compromise of the system of evidence, which would occur through public availability of admissible evidence. And four, the rule seeks generally to uphold the public interest in the due administration of justice. So I thought I should bring this out because I've seen it as as a common practice, which I think is, as advocates, we need to resist from it. We should therefore all take serious the issue of the observance of the sub judice rule. I know, of course, internationally there have been issues to do with, advertising. Should advocates advertise? There are all these issues now with the advent of social media. How do we deal with them? But I think as long as we still have these rules, let's follow them until they are amended. As advocates, I wish to remind you to view justice as a three-way traffic. Counsel must appreciate that his or her duty is not only to his client, but extends to the court and the society at large, whose overriding interest is in ensuring that justice is done to all cases. Now, I was in Singapore, so they have a tool which writes judgments. So you fit in facts, and so it drafts for you a judgment with the authorities. It applies them actually. So you read through as a judge, and then you say, okay, I agree with the AI, or I disagree. So one of the situations they faced, in one of the cases, the tool quoted two non-existing cases. So when the judge was reading through, he found there were two non-existent cases. So then they said, but how can this tool, AI, do this? How can it pick a non-existent case? It was discovered that actually the advocate had used it in his submissions to a judge at some stage. And the judge also applied it. You can imagine that is his reality. So you sit and you say, now, my Lord, how do I convince him? Then you say, the Supreme Court once held. So you create your own case. So what I'm trying to say is that, this duty is to the public, to your client, and to the courts, because you are officers of court. So Now, to the court, an advocate should be respectful and courteous towards the presiding judicial officer. The reverse is also true. Let us all remember that respect is earned, not demanded. I mean, courtesy deserves nothing. I went to one of the open days, court open days, where a senior lawyer came and told me that the judge called me stupid. Then later I talked to the judge and said, my lord, surely you look at a senior lawyer and you call him stupid. He might be, but you don't have to tell him so. Because that's what courtesy demands, that mutual respect between the bar and the bench. Even the judge, I think I remember the late Wairama who used to say, the drunken judge heard, in class, when he was disagreeing with the decision. He would say, the drunken judge heard. Of course, he would do it jokingly. He would say it jokingly in class. But you imagine you at the bar, saying the drunken judge decided as follows. So I think really that shouldn't happen. So advocates have a duty to assist the judges in the trial of the cases to arrive at a proper decision by presenting the relevant evidence and the law in a proper manner without concealment of material facts that would otherwise be helpful to the court. Now, you find sometimes you have a criminal trial. You know that the DPP is supposed to disclose evidence. Now, the DPP hides the evidence. You have counsel who is supposed to disclose, to disclose the evidence to the other party. Counsel thinks that he should ambush the other party. I think that's not proper because it's not your case. You are an officer of court, although you are representing your client. So I think this is an area we need to. The advocates are called upon not to indulge in conduct that is intentionally calculated to delay the trial. Now, my lords, I have had so many complaints. Like I receive a complaint where counsel is saying, my colleague has filed a case in land division. Let's say it's a mortgage. He has filed a case in land division, has filed a case in the commercial division, and maybe the wife is also contesting and maybe it had some elements of family. He has also filed in family division. I always try to aggregate them and then send them to one division to hear them, depending on the relevance. Or sometimes I call the heads and say, where do you think this should be handled? And I aggregate the file and send them. But I think that is misconduct, my colleagues. Why would you do that? Because all those issues can be either handled in one court, or so why do then filing unnecessary applications. Actually, in law reform, since you are represented there, we are mooting an idea to find a way of punishing advocates in the rules themselves, where you find someone is just filing unnecessary applications to ensure that the matter does not proceed or does not end. We are mooting something with the consent from your colleagues there, because you are represented at the law reform, which I chair. Because we can't continue like that, my comrades. Why do you want the matter not to end? Then you have forum shopping. One of the interesting forum shopping was a case which was supposed to be in Barara Court and someone filed it in Soroti. You can imagine. I'm not going to mention who, but you know yourselves, and you know the advocate. Okay, then the court expects advocates to stick to the timeline set by the law or issued by the court. Now, you see, orders of court are not made in vain. Now, you come to court and you are grown on timelines, and then nothing happens. I'm also complaining because I know you're also going to complain. So let me complain before you do. The advocate must maintain court decorum. Now, I have seen, I don't know where this problem is coming from. John Mary Mujisha is appearing before me with an advocate of 2 years in practice. And he stands up and says, my Lord, I'm so and so. I want to introduce my, surely. I mean, we studied professional conduct at RODC, so I don't know where the problem is, but it's maybe in your own forums, you should also discuss these issues. You know, I remember when I was an advocate, we used to respect senior lawyers. If, for example, they had read my file and I was about to proceed, and John Mary Mujisha came in, I would tell the magistrate or the judge that, my lord, my senior is here, kindly start with him. At that time, they used to fix cases, you know, like you would come as many people, and then they would hear, you know, whoever is available. These days, we change it a little bit. We give you time. But at that time, we used to do that as advocates. Respect your seniors, respect your colleagues in court. Don't shout. One time I had lawyers who almost exchanged blows in Mbarara court. I have never shouted at the lawyers, but for the first time I did. I told them, get out of court. In fact, I said, let me call, you know, lawyers fighting on the bar. So you can see. So at that, at that stage, I think the decorum has escaped through the window. Okay, an advocate should not be seen to connive in the branch at contempt of court orders. So I think this is self-explanatory. I don't want to go into it. So to the public, the advocate is expected to act with the integrity and avoid the following. Number one, corruption. I have cases, I have matters where advocates have created non-existent cases, and I have arrested some of them at execution level. Well, there is no case. I think the most interesting one was against Makerere University, where people created a fictitious arbitration and filed an award. And at the time when I got to know, they were almost the following day, the registrar was supposed to issue an absolute. You can imagine, a Ganishi absolute. So now I had to, because I was informed by Makerere University at 4. I tried to call the registrar, her phone was off. I had to call the manager of the bank and say, kindly do not implement that order. There is a problem. Meanwhile, you can imagine, a fictitious arbitration. How much money were they taking? 2 billion. And the lawyers were involved. So these are thieves in robes, in advocate robes. You can imagine. There are many, I have so many examples. There is even one, I think, one of which I have on my desk, which is even worse. Where they filed the case against the person, and when it came to execution, I think the bank fortunately called him, and they said, some money is about to be withdrawn from your account. How much of it? 600 million. And immediately instructed his lawyers, and the lawyers went to court, and there was nothing. So they had, they created a case, and the other party did not file a defense, and they moved on. So that is criminality, really. Then the other problem, which I've received these complaints, which I sometimes refer to Law Council, I advise the complainants to go to Law Council, withholding funds received on behalf of clients. That is common, comrades. You get money, it is for the client, you swallow it. Sometimes you may actually not do it with an intention of not refunding it. But I can tell you, you may be expecting a bill of costs. Then it takes ages to be concluded. Where you thought you would recover the money and repress. And then you find yourself in Law Council with all your titles, senior counsel being failure to account for the clients for the money paid. I think these are related. and then failure to render professional services, e.g. inadequate representation in court and lawyers, failure to appear in court to execute instructions after being paid. This is common. And I used to see this, I don't know whether the advocates here in Masaka, I remember when I was a judge in Masaka, I used to get situations where lawyers would come and the lawyer would come to adjourn for the other in the same case. Now, I later discovered that those two lawyers were actually, I think John can remember this because we were together there. These lawyers were actually receiving, were being paid per appearance. And when I looked at the file, the case had been called 54 times without a hearing. So the more they appeared, the more they earned. Then of course that's really painful. So one time I asked, so ordinarily when you come as counsel, you're supposed to say, my colleague is not here, and this matter was adjourned in his presence. I proceed ex parte. You know, but this one, the other one would say, my colleague is not around, I pray for adjournment. And so the next time the other one would appear, the other one doesn't appear. A partnership of criminality. Okay, then charging exorbitant fees, which deprives the poor and the marginalized of access to justice. We have a schedule which shows us how much we charge. But you have seen some situations where you enter into agreements, charging 50%. In fact, one of the interesting complaints I received recently is where I think they were supposed to recover 7.5 billion, and the advocate entered into a memorandum of understanding to take 4.5 billion. You can imagine, so almost taking 3/4 of the amount of money to be recovered. I don't know which schedule the advocate was using. Now, conniving with errant bailiffs frustrated due process in execution. Of course, this is I think, comrades, you know that execution process and what happens, where you even tell your bailiff, go and arrest this person, lock him into the car, lock him inside the car, and put him on the, dry him on the sunshine. When he feels the temperature, then he calls the relatives and says, please, you people bring the money. And the bailiff is doing that and you are aware, he has informed you. Okay, then, to your colleague, the advocate, you owe them the following duty. Honor legitimate promises made to opposite counsel, even though not reduced in writing or enforced under the rules of court. Now, as an advocate, I've appeared with John Mary Mujisha, and I've told him that counsel, we are going to settle this matter, and then I pass behind and do something different. That agreement, between advocates should be honored. You should be honored by your word as an advocate. Don't say A and you do B. Then act courteous, not to indulge in bitter exchanges in open court and outside the court. I've seen it, letters which you exchange. We have seen your notice of invitation to sue. Any serious advocate worth his salt would not pen such a missive. It is idiotic to say the least. Surely, you are calling your colleague an idiot for. Okay. So on the part of the bench, now this is on our side. I've consistently informed our judicial officers to ensure the following. Number one, zero tolerance to corruption. I always tell my colleagues everywhere I go that you imagine when we are seated at the bench, there are two sides, litigants, all of them having legitimate expectations, looking at you as a serious human being. They have hopes in you. And when you look at their faces, each person is really, he has hopes that you are going to do the right thing. Now, if you really, you engage in corruption, now let's say you receive a bribe in the morning and in the afternoon, you are mentioning cases of bribery in court when you should also be on the same charge sheet. So I've always mentioned that. So I mean, as judicial officers, we must be above reproach. Then certainty of hearing dates and timely hearing and disposal of cases. I've always told my colleagues that, for example, if you know you are not going to be at the station, kindly inform the lawyers. If you have never practiced, you don't know what it takes for an advocate to move from Kampala to drive to Arua and find you are not at the station. It is very painful. And we have so many methods of informing advocates. We have the Uganda Law Society forums where you can post this information. And sometimes we create individual forums within the circuits and divisions. Kindly inform them in time, because it's painful, both to the client and to the advocate. For someone not to know to know that the case is coming up on a particular date, you are not at the station. Then timely delivery of judgments and rulings. Our law, of course, talks of 60 days after conclusion of the case, of course, after submissions. So the law gives us 60 days within which to deliver the judgment. Now, even if for some reason you may delay a bit, but at least make sure that you expeditiously do it. The next one is observance of good customer care practices. I've told our colleagues that every time these advocates come to our courts, they must have, that courtesy, the reception, but not only advocates, but also their clients. Then, timely availing of certified copies of the record of proceedings and judgments and rulings. Sometimes our colleagues think that when someone says, I want to appeal your decision, that you find it's a problem. The different levels were put there for purposes of cleaning up our judicial system. That if I lose at the magistrate court, I should come to the High Court and have my take there. If the High Court agrees with the lower court, maybe I go higher. If the higher court agrees, then I stop. So I think we should be able to avail this. I know we have challenges within our system, especially lack of secretarial services. We have few secretaries, but we are trying to recruit. I think sooner than later we shall solve that problem. And then, of course, so I will tell you that at the strategic level, judiciary is continuing to make interventions intended to make it easier for you to do your work. Number one, we are recruiting more judicial officers, and I'm sure some of you will come on board. And we are in the recruitment process. We are going to have more Court of Appeal judges, 5 of them. And then we shall also have an additional 10 judges of the High Court. So we think that with that number, we should be able to, and it will be incremental. So we think that intervention should be able to solve some of your problems, especially backlog. We are hoping that at one time you should be, the longest you can be in court is 6 months. We are trying to operationalize more High Court circuits and magisterial areas. We recently issued a magisterial instrument, and I think you must have had a look at it. So we are having more court circuits, and we are increasing, we increased them from 24 to 38. And now every district is a magisterial area. Further, we are decentralizing the Court of Appeal selected regions. We are starting with Mbarara and Gulu, and we are beginning construction this coming quarter in Mbarara as well as Gulu to construct the Court of Appeals. So we shall decentralize it. So that, and then next it will be Mbale. At least if we have in those regions, then we shall now come to the 8. So that should be able to ease our burdens. We are decentralizing the inspectors of courts in selected regions, and so that if you have complaints, you shouldn't be able to travel to Kampala. You can do those complaints at the region, and the inspectorate can help. We are organizing trainings for both advocates and judicial officers in the new areas of the law. At the moment, we are carrying out training in respect of the amendments we made in the civil procedure rules, because you notice that when you go to court, for example, summons for directions, you will find the approaches are different. I've seen even where lawyers have made written submissions, and so we are trying to we are trying to train judicial officers as well as lawyers. And apparently, I think your colleague complained here that when they call you for continuous, you call it what? CROE, continuous legal education, CROE. When they call you for that, many of you don't want to attend. You think you have arrived. Learning is a continuous process. You only stop learning when you die. So always go for these trainings. Improving stakeholder engagements. Now, you notice that last time we had a court open day at Kororo, and we are continuing to engage members of the public, and as well as you, so that any problems we face, we should be able to solve them together. Then we are rolling out innovations such as ICMIS. And now ICMIS, I know there are some courts, I heard you complaining about Ginger. Ginger would have, it was one of the courts that was supposed to have ICMIS at the beginning, but we had a problem with the cable. There was a dispute on where to pass it behind the court. I think that's where the access is. But I think there has been a problem of that cable. So I hope the problem will be solved. We have been engaging the town, the city, it's now a city. So I hope soon it will be solved. And of course, we shall roll it out in other divisions. For example, family, criminal division. I think beginning of the next year, we should be able to roll out. So that, and then maybe subsequently to the circuits. As I conclude, let me inform you that the judiciary has come up with strategies to re-engineer ADR in the disposal of cases. I thank you for coming up coming around for the ADR week. It was successful, and of course ADR provides a win-win situation. I know, of course, through school we never taught, ADR. I remember John Mary Mucha when he was teaching us at the RODC. He was concentrating on cross-examination. How do you cross-examine a stubborn witness? And then he would do, ROA, and he was very good. So that was our concentration. No one ever told us that you can actually dispose of a case through ADR quickly, and you get the benefits. So I think let's take that direction. Now, with these few remarks, I thank you for listening to me. I wish us all fruitful deliberations. Now, I think you raised some issues. Maybe I can respond to them, and then we shall take more questions. I think you talked of tracking resolutions and discussions. I think I remember one of the meetings where we agreed that we should have, our secretary should take minutes, and then we generate action reports. And every time we come here, we should be able to say, we agreed on this. How far are we? So that we don't come here and then discuss the same things we discussed without informing you how far we have gone or how far we have failed. Then, raising complaints, I think you talked about that. Of course, now, complaints, I receive an average of 20 per day, countrywide. Now, some of them, you find a person has traveled from Moroto. My office is always like, the line never breaks as long as I'm there. Now, someone moves from Moroto to file a complaint before me for a solution that he or she can obtain in Moroto before the resident judge. So, of course, I've had complaints, and I've discussed this with my colleagues, that many people tend to say that when they come to you, let's say you are head of division, they come to you, you don't want to antagonize your colleagues in the division. So then you refuse to handle, and then now someone has to find his way now into my office. And my colleagues, let me tell you, leadership is not a popularity contest. If you're in leadership, you have to take sometimes hard decisions. People will abuse you, they will hate you, but unfortunately, that is the fate of a leader. So maybe we need to, internally, we shall find a way of easing that process. But when you go for court open days, we try to tell the public that please, when you have a complaint, start from here. When it is not addressed, that's when you should come to us. Then lawyers not getting feedback from the judges, at least I'm not one of them. When you file a complaint, it may delay a bit because of the work I have, because of the nature of the office, but at least I will respond. And my colleagues, I think you've heard the verdict is out there. The jury is out there. Let's respond. If someone writes a complaint, you know, say, I will handle this or I will not, so that the person knows where to go next. Now, there are issues concerning GICMIS. I think there are so many issues which you raised in the past. We've been trying to solve them. Some of them concerning the bandwidth, which sometimes maybe could be an issue because we get internet from NITA Uganda, but we are trying also to find a way of circumventing that by also acquiring our own internet so that it supplements NITA Uganda. Maybe some of these problems will be solved in future. Inconveniencing lawyers on getting dates and notices, etc. I think I earlier mentioned this in my address. I said, I think for lawyers, we need to make work very easy for them. And I think he mentioned that to follow up fixing a case in a court is a pain because the lawyer should be using that time for something else. So we need to make it easier for the lawyers. Find a way of how you can make it easier for the lawyers to get dates, hearing dates. If you are to adjourn cases, at least make sure that even the date of adjournment are also clear, so that lawyers would not waste time moving back and forth looking for dates. Then judiciary getting worried about elections. I think you mentioned that. Let me tell you, we are not worried. Worried about what? Eh? No, we are not. Eh? We are not worried. We have two divides. We have the Law Society, we have the bench. Well, whatever you do on your side, that is your business. Okay. Then I think Attorney General, you talked about complaints on social media. I agree with him. You know what we call mob justice. Because you know, on your forums, you find you complain about a judge, and then everyone is throwing all jabs. This one calling him a fool, or this one surely. On social media, advocates trained. You see, sometimes their comments very nasty. Then respect between the bar and the bench, I think this is given. And John Mary Mugisha, I think, talked about it. And I think I also agree with it. We must have that mutual respect. There are certain etiquettes. For example, in the army, you may have a commander who is a fool, but he's your commander. Now, this etiquette was put there to ensure that the army operates smoothly. That's why there was that decorum which was put between the bar and the bench so that litigation can move smoothly. Otherwise, if you were allowed to come and that's why there is the law of contempt. If you had come to the judge and you say, but who are you? Do you think you are more intelligent than me? You are a fool. I mean, what would that court be? So some of these, guidelines were put there to ensure that there is smooth administration of justice. So even if you believe that the judge you are appearing before is not your, be courteous until you get a wrong judgment or a right one. Be courteous. And then of course, as judges, we should also do the same to the advocates. Delay of cases on both sides. I agree with you. Many of the advocates sometimes try to delay cases. And of course, on our side, there are those who, I remember when I was in practice, there was a judge who retired, and I think is deceased. Whenever you would appear before him and you say, my lord, I want to judge, say, oh, yeah, yes. Immediately, he wouldn't ask you why. No. Yeah, counsel, it's okay. So now you can imagine that judge delays the cases, and then there are lawyers also who want to. Then, of course, case backlog. It's an elephant in the room. We are trying to tackle it from both sides. Quality of decisions, yes. I've seen some of our decisions. Yes, you see one of them and then you say, eh? I'm sure you know what I'm talking about. Eh? Yeah, sometimes you see a decision and then it is being shared on your social media, the ours as well. And then the judges are also talking in whispers. Hey, our colleague. Yeah? This is terrible. So I think we need to we need to be very careful. Of course, we are human. We are supposed to make errors, eh? But let those errors be, okay. Then fighting online should be rolled out. I think, as I've mentioned, we are trying to. I think next year we should be able to roll out ICMIS to many of the courts so that we can ease your processes. Thank you for listening to me. I could have taken long, but I thought I should answer before you answer. Sorry, before you ask more questions. Thank you.
Let us give another applause because it was very enriching. Now, my Lord, when you were speaking here, I was thinking and praying to God that when I grow up, I want to be like you, because you have ably presented those issues. And I want to inform you, my Lord, that online we have 182 participants. And when we were proceeding, we were joined by the Deputy Head Land Division, Honorable Mr. Justice Tadeu Asimwe. You're welcome. I also saw in the audience Senior Counsel Bruce Chirere, a little bit very far their side. You're most welcome, and many are still joining us. My Lord, we would like to go into the comment section where the members would like to make some reactions. And I shall start with the comments online. And one is from Mr. Mosana Simon Peter, where a judicial officer issues a second warrant of arrest to commit a judgment debtor to civil prison following an earlier release of judgment debtor by consent of a judgment creditor, contrary to clear provisions of the CPA, that a judgment debtor, one released, cannot be rearrested in execution of the same decree. Is this passive corruption or lack of clear appreciation of the law? That is the comment from Mr. Mosana Simon Peter. We have another comment from Leonard Casivante. Why don't compensation cases as a result of land appropriation be considered urgent matters in light of the decision in UNRWA versus Irumba, Supreme Court Civil Appeal number 2 of 2014? Those are so far, and as we get more, we shall be displaying them, my Lord. The members,
maybe to say that yes. I have I'm not here alone, so I have my colleagues, the heads of divisions. So when you are roasting me, roast them as well. Don't leave them alone.
My Lord, I didn't want to say that one. But it was a very good selection, my Lord, so that they are present on the front line. Members, if you have any reactions or comments, please raise up your hand and feel free to raise these concerns. We have a microphone that will reach you at the soonest. Okay. Yes, that is Mr. Mtavingwa. Please.
Thank you very much. I have a few comments. And last year when we had the back bench, I had raised some, but I have to repeat them because they have not been addressed. I have had the various speakers speak about the problems we face, and I have categorized them. You see, in this world, we have two types of problems. The first ones are the ones which bring themselves And those ones are very hard to address, but they can be addressed. But the second ones are the problems which are caused by man. So most of the problems we are talking about here, they are created by ourselves, by man. And most of those problems, they revolve around 4 issues. And that is what is hindering the administration of justice in this country. The first one is corruption. You have been seeing the indicators of corruption every year. The first one, police. The second one, judiciary. That one is not a very small issue. It has a bearing on the quality of justice in this country. Then the second one is incompetence. Incompetence. The third one is laziness. The fourth one is dishonesty. So all what you have been talking about, they revolve around those 4 issues. And those issues, they are created by ourselves. Corruption. Who can say that we don't have corruption in the judiciary, in the advocates? Advocates, we are not clean. We are making the work of the judges and the judicial officers very, very hard. I can give you an example. I was applying for, no, a client came to me. A lawyer had asked him 80 million to take to a magistrate at the anti-corruption court to be granted bail, but they didn't have the money. So they came to me. They said, can you help us? I said, I help you. And I don't want any money, but me, I'm sure you are going to get bail. Because the magistrate had not asked for any money after all. So I went, I applied for bail, and the person paid only 5 million and got out of what? Of jail. So those problems, they are created by advocates now. Advocates are thieves. Actually, we are not practicing law. Most of us, I have already said this, we are not practicing law. We are practicing thuggery. People are thugs, I'm telling you. And it is very unfortunate. Most of these thugs, they are now passing to the bench. We have thugs at the bench also. And the problem, I mentioned this at the lawyers conference. We don't have a say in how these people are appointed. I don't know whether we have a representative of the JSC here. People apply to be judges, people apply to be magistrates. You hear some have been appointed, others have not. I have not applied to be there. But me, if I was there, if I'm told I have failed, I would go and ask how many marks have I scored? Has any of you gone back to ask? No, you are told you have failed. Then you wait for another time to apply and fail again. And then you hear some people have been appointed. You don't ask the person who has defeated you, how many he has scored. No, the show goes on. That is what is happening. So we are not getting the best. You see, our profession, the legal profession, we are supposed to be honorable, both judges and advocates. But what kind of people are we? What kind of advocates do we have? What kind of judges and magistrates do we have? We are not practicing law. We are practicing politics. The law of survival. Everybody wants to survive. And we are leaving the law aside and we are practicing the law of survival. That's why magistrates, before any bail, most of them, any bail is granted, they want cheat dog. And even I can challenge the PJ. Go to your courts, magistrates courts, both here and the upcountry. See how many people are paying bail. People are not paying bail. They say court bond. But the magistrate has taken money. But that one is called court bond. You go there, you go to your files and see. So that is what is killing us. Then incompetence. When a person is appointed as a judge or a magistrate, it is finished. Security of job, security of tenure. Mr. PJ, Honorable, do you go back to see what kind of judgments, what quality of justice those people are delivering? Well, you see, we are concerned with clearing the backlog, but we are not concerned with the quality of justice in this country. What kind of justice are we getting? You have had some judges who cannot differentiate between a ruling and a judgment and an order. What kind of justice are we getting? That is where we should be concerned. We are not. And that one comes from incompetence. Incompetence. So how shall we deal with the problem of incompetence? I had suggested last year during such a meeting that maybe there should be a committee to review the judgments of these magistrates and judges so that the quality of justice people are getting can be ascertained. And I can tell you, Mr. Principal Judge, I mean Honorable PJ, the process of appeal is very complicated. It is almost impossible. Nowadays, how long does it take to handle an appeal at the Court of Appeal? They say you go appeal, you go and appeal. You have lost your case, a client has lost the case, then the process of appeal. Do you know, like at Court of Appeal now, they are handling appeals of 2009, 2010. Now we are in 2024. So what kind of justice is that one? So where are we heading?
Okay, thank you.
Then I have other general problems now.
Please,
I wanted to see.
let us be brief
Yes,
on them.
Yes, Your Worship.
Please,
I'm going to take like a minute or two. Now, I wanted to see the person who has put the family court where it is. That place is not fit. Actually, that person should have come here and explained to this congregation why he put the family court where it is. The place is very narrow. There's no parking. We have to go on borders. And you see, that building has 3 divisions. It has ICD, it has anti-corruption, it has family division. Family division has so many people, it cannot fit there. The place where we are supposed to park is taken by Minister of Health staff and other staff. So that place is not fit to be a court and should be immediately vacated and taken to some other place. There is also an epidemic which is about to happen at Ruzara Grade 1 court. I went there. You go and look at it is not a toilet, it is a latrine. People are going to be sick. I found there prisoners going there. That place I'm telling you is terrible. You go and look at it and you will close the court immediately.
Finally.
So finally, I appeal to each and everybody here. If you are a lawyer, if you are a magistrate, be honorable. That's why we say, my lord. I have always told people that some judges, I refuse to say my lord and to bow. Because I know you don't feel, you don't deserve that one. Let us deserve that. If you are a lawyer, be a lawyer. Be honorable. If you are a judge, be honorable. And you will see how things move. And you will see how we get justice. Thank you very much.
Thank you very much. We have Council Chandia, and after we shall have another online comment.
Thank you so much, MC. And I thank you, Honorable PJ, and everyone present. I observe the protocol as earlier laid. PJ, I felt a bit uncomfortable, and I thought I needed to say it candidly as we were asked to do so. I think we are repeating ourselves, and I think we are wasting a lot of time. I thought we needed to have had some track of what had been discussed earlier. Number of issues were laid by the ULS, and I know senior JMM here was a mouthpiece in raising those matters before a bar bench previously had. It's unfortunate we haven't had feedback in terms of what has been done to address those issues. And I think it is a disservice to all of ourselves. And I would pray, my Lord, that critical action is taken to ensure that what we discuss in forums such as this are truly followed through for the betterment of all of us and in administering justice. I want to make a comment also on the use of social media you had alluded to. And you made a comment on the doctrine of sub judice, and quite elaborately well. But my Lord, I think the rule you cited needs an urgent review in light of the developments in technology You had alluded to even now courts in some jurisdictions where artificial intelligence is being used for drafting judgments. And we are here complaining on social media and its usage. What will happen when AI visits us seriously? I think, and I'm proposing, that there perhaps needs to be some policy position with regard to how can advocates present themselves on social media. It's their right to, and judiciary has those handles as well. But what is the expected level of professionalism that is required of an advocate or an office of court for that matter? I thought that needs to be an urgent matter, just to say that there are issues to streamline. Perhaps the question is, what has gone wrong? What is causing these problems that we are attempting to streamline? And unless we have knowledge of what the causes are, the streamlining may be futile. And so I would pray, my Lord, that this needs to be put into careful consideration. I've had a few opportunities to speak to the lower bench. Some of the magistrates, my Lord, there are some who have low morale to work because someone has been in the same position for years. They don't find it palatable coming to work. People that joined the bench before, after them, are rising way above them. And what is the criteria for promotions within the judiciary? And we are facing some of these challenges. They show themselves off in absenteeism, unnecessary adjournments, and sometimes leaves. One other issue, my Lord, I wanted to point out, which touches with what my senior Max Mutabingwa had talked about, which has to do with competence. My Lord, it would be good to know the criteria, especially that you use in assigning judges to particular divisions. We have had experiences in some courts where a judicial officer who has come from a background, let's say practicing purely criminal law, is sent into a division which is dealing strictly with civil law or civil practice. And the judge practically has struggles appreciating, first of all, the law and how to apply it. And many times, these are the challenges we face. Judgments are not coming out because there is incompetence. That incompetence comes because I think the person has not been properly allocated. If they were given maybe the criminal division, you would find them performing much better. Can that be looked into, my Lord? I would pray. And lastly, permit me to raise the question of judgments being delayed. It is a very serious concern. There are judgments some of us have been expecting since the close of COVID until now. They are out, not out. The 60-day rules seem not to be working. What practical solutions can be given to us? I humbly submit.
Thank you very much. Let us have the online comments. We have Josephat Motesasira. There is a need to merge the High Court divisions in respect of barring filing at several divisions. Wow, that is the forum shopping, I think. Number two, what is the judiciary planning to do to curb filing at multiple divisions? Seems the same. We'd like to inform you that we have a matrix drawn for the last bar bench meeting, and we are going to display it as soon as we are done with these comments. From Dagan M. Omwesiga, we need guidance as to how judiciary handles the issue of mandatory bail applications. Recently, we had a matter where bail was denied. After all, the other conditions were met in High Court because the lower court hadn't sent a file. Is this not an injustice to the applicants? Nyijukire Faston, why has judiciary failed to recruit more judicial officers into judiciary? The lack of enough judicial officers has costed Ugandans a lot as far as justice is concerned. Mwesigwa Apollo, thank you so much, my Lord, the Principal Judge, for this meeting. We are requesting for a second judge at Luwero High Court. The current judge is overwhelmed by the workload. Thank you, my Lord. Yes, those who are online, can we have the microphone now, this other side? Yes, we can have from the left to the right.
Thank you, my lords. My name is Councillor Anne Karunji. I'm glad to be part of this august house. Mine are two comments. One of them is that we need continuous training for judicial officers at the lower bench. If you look at, in order to improve their quality of work, for example, I was called to handle an appeal arising from one of those matters. And when I perused the judgment, the judicial officer had ordered for strict supervision rights. And when I looked at the grounds why, and in her judgment, she wrote, because the applicant had acted funny while visiting the child at school. So I went to this judicial officer and asked her, Your Worship, really? What is the interpretation of the word funny? What is funny? Huh? It was quite appalling, but on appeal, we were able to get what we needed. So I am calling for continuous judicial training. Another one where I raised the issue on feed and judges were there is where she issued a warrant of arrest for guarantors of a man who had died. You know, when a judgment debtor dies, you proceed against the legal representatives of the estate. You don't go to the guarantors of the man who is dead. So I said, which person did this? And it was, you know, judges discussed it, and she finally did the right thing. So I am calling for really continuous training. Then secondly, we are calling for judicial officers to study their files. Some of the reasons why we delay in courts is because judicial officers, some of them do not, with all due respect to those who study. We have reached a point as lawyers when, you know, when you're going to someone's court, some judges we know better prepare and prepare. Then there are, you find someone, a lawyer, bringing a suit in the form of trying to execute an order that is 14 years old, that is stale, and hides it behind a suit. There is a judicial officer who is now retired, who I told when he was about to deliver a ruling, I said, my lord, I had the benefit of reading the case of Justice Madrama of Green Pastures that talks about stale court orders. He said, thank you for bringing it to my attention. So I am calling on judges, some of the judicial officers, to study your files. Once you have your finger, no matter how a lawyer tries to hide a suit, you know, a frivolous suit, you will be able to, look at it and find it out and have that matter dismissed on a point of law, a technicality. I thank you.
Thank you.
Thank you, Masters of Ceremony. Thank you, my Lord, the Honorable Principal Judge. And I adopt the protocol as laid out down by the Master of Ceremonies at the beginning. I take this as it is a forum between the bar and the bench. And I would like to agree with my brother, Council Chandia, that there's nothing new that is coming up. These issues are real. They are the same issues that we are dealing with. My Lord Principal Judge, you did talk about public confidence. And for me, that is where I want to ground my contribution this afternoon. That as the bar and the bench, whatever we do, what we're actually looking at, we are looking at improving public confidence in the judiciary, in the legal system, and we are players, we are partners in this. We need to recognize that we both have significant roles that we play as a bar and as the bench. For me, that is the starting point. Of course, having said that this is a meeting between the bar and the bench, ask my brother, society, we've had a meeting since the last bar bench forum, but I think I'm not aware of any. So maybe our president, maybe a new president that will come into the new executive, the new council. We need, after these meetings, we need to meet as a society, discuss the things that concern us, because it affects me, and again, it affects public confidence when as lawyers, we are calling ourselves thieves in front of the judiciary. I don't think we are all thieves. Yes, there could be some thieves, but not all of us. If we say all lawyers are thieves and you carry the title of an advocate or a lawyer, then you're calling yourself a thief. And for me, this is not the place to discuss these things. We need to have our own engagement as the bar, and then we split airs, we discuss. My Lord, my contribution again here is that we need to look at structural issues, structural strategies, structural approaches to resolving these things, because they will keep happening. Of course, I may be going ahead, perhaps after we've heard from the metrics that will be displayed showing what has been done. And I think we need to give credit where it is due. Some things are being done right. Personally, my Lord, you remember I had a matter that I brought to your attention. You were very swift and you acted, and the clients who were Chinese investors, they were satisfied with that. I will not give the details here, but some things are going right. Some things may not be going right. So I think we need to focus on finding foundational solutions to these. My Lord, public confidence, I'll leave with questions. The 5 key questions, in my view, that will help improve on public confidence in as far as the legal system is concerned. Do people believe that this legal system solves disputes quickly and honestly, providing speedy justice, and thus maintaining law and order? Whatever we do, whether as a member of the bar or as a member of the bench, we must answer that question. And if we answer that question in the affirmative, we are improving public confidence in the judiciary, in the legal system, and in turn. The second, my Lord, does the system recognize the voice of the voiceless, the marginalized groups in matters that you sit as judicial officers? When these matters come before you, one has money, the other doesn't have money. But your decision, is it just? Is it listening to the voice of the voiceless? My Lord, the third, we need to answer the question whether people believe that we are facilitating an environment that necessitates economic growth. I come from a commercial practice area, arbitration and construction. It is very important because in every construction contract, whether standard forms or tailor-made, most times the dispute resolution mechanism is through arbitration. Now, I want to relate to this particular question. If people go and arbitrate, and these matters come to court, and the courts are not proactive in supporting the arbitration processes, when my brother representing the Attorney General or the government is signing these contracts, they will keep insisting that let's do arbitration in London, in Paris, and that is very expensive. So we need to build this confidence, whether for the public or investors, whatever it is in dispute resolution, that will encourage economic growth. My Lord, this may not be the time, but in future, I humbly suggest that borrowing from the UK system, let's look at having a construction division that is handling construction disputes or matters that are coming within that, because it involves a lot in the economy, and we need to specialize in that area in terms of dispute resolution, or a division for that particular purpose. Perhaps we'll study this, we'll do independent research and find out how many construction disputes are in courts of law, so that we can start preparing towards that direction. My Lord, another question is, do people believe that the legal system prevents absolute power and corruption? We are all talking about corruption, corruption, corruption. But this has to be seen. The members of the public have to have confidence that the system is preventing absolute power and corruption as an efficient check and balance in government. Lastly, my Lord, we as a legal system, or the legal system, should be able to be a watchdog for this country. This is in line with, as one of the 3 constitutional aims of governance. This is very important. If whatever we do, we answer these questions, whatever solutions that we'll suggest, let us answer these questions. We shall be moving, because we can talk small things, but these problems will never be resolved. We need fundamental fixes in terms of structure, in terms of systems, that eventually will weed out the bad practice, whether from the bar or from the bench. Eventually, we'll be able to move to the right direction. My Lord, we'll look at the matrix. Actually, on a light note, when you said that when you look at the judgment, you say, I was wondering, I was expecting what you're going to say that you did about that judgment. Thank you.
Thank you very much. Do we have any more online comments?
It was just a
Oh,
comment on
please.
ADR strategies.
Okay, please.
My Lord, the Honorable Priest, my name is Laston, and I will observe the protocol. My comments are just 2 on ADR strategies, my Lord. My Lord, we commend the steps that are being taken by the judiciary to implore faster resolution of disputes through alternative dispute resolution. My comment and proposal is that sometimes the move to go to ADR is coming where cases have already spent in court quite some time. Would there be a mechanism where courts are identified probably at the earliest that they are referred to either mediation, so that you don't have parties that have waited for hearing? We have complied with all the preliminaries. We filed all hearing documents, and then after 2 years of waiting for hearing, that is when you're asked to go for mediation. It's sometimes difficult to get such parties to already agree to a process they have waited for a long time. Although mediation, including at appeal level, is really helping. The other, my Lord, is the challenge where you have certain circuits or certain courts adopting a certain practice of handling disputes, but it is not documented. So what you have in the law is different, but what you find at the court is also different. So there is a divergence between what the law provides for and what the practice is at the court. The practice is okay, but only that because it is not documented, sometimes you find practitioners, either if they are new at that court, they end up finding challenges, and a client is asking you, but you gave me a legal opinion and advice that these would be the steps, but we are ending up at court, advancing in the dispute, and then something else is coming up. This is our proposal, my Lord, that having benchmarked very good practices, I'll give an example of the commercial court, I'll give an example of equally the civil division, specifically the commercial court. When you are having cases coming up for the first time before judges there, usually the judge will be able to identify what are the pain points in this case. And if it requires the judge to give the parties time to just step out and talk about the issue, that happens. However, my Lord, in some instances and some divisions or circuits where it is not documented, for example, even at Court of Appeal, the position at the Court of Appeal as of today, my Lord, is that no interim applications for stay are had. The focus is on the main stay, and it's understandable. However, if you have an exceptional case, what happens? Where do you go? what do you do? Because the court has done well now that single justice has determined these applications to first, they even issue conferencing guidelines in the applications, but in the exceptional circumstances, is this practice documented? Are there guidelines? And that will be our proposal. Thank you, my Lord, and thank you, colleagues.
Thank you, my Lord. With your permission, we have 2 comments online, and after which, my Lord, we shall proceed to the matrix. We have anonymous attendee. A registrar at the Land Division issued an order technically staying an order of the Court of Appeal. Incidentally, we had written informing him, we badly want to respect judicial officers. Why do some of them provoke us? My Lord, another anonymous attendee. A certain judicial officer at the Civil Division lacks judicial decorum and courtesy. Please encourage him not to shout at advocates. Please encourage him to be courteous. Thank you very much, our online participants, for equally sharing your thoughts on this important meeting. Let us have the matrix of the last bar bench. Wow. So that's the bar bench matrix held on the 21st of February 2024 at the Sheraton Hotel, Kampala, hosted by the Chief Justice in partnership with the Uganda Law Society. And the concern raised, number 1, by the bar was case backlog and delayed disposal of cases. The feedback from the bench was frequently cases. Oh, I cannot read quite much. Could you aid me? Yes, that's better. Frequently cases from tribunals escalated to the High Court, making it practically challenging to address the case backlog due to the understaffed nature of the High Court. Additionally, Court of Appeal justices are prioritizing rulings over judgments in response to the rising number of applications. The proposed action was to embrace ADR even before court proceedings, recognizing the benefits of resolving matters outside the courtroom. Additionally, the judiciary is actively promoting appellate mediation, which provides an efficient way for people to address their cases. And the responsible entity was the bench. The second was judicial process inefficiencies, and the courts direct on scheduling and give timelines on when submissions to be filed. However, advocates do not follow these timelines. It is crucial for parties to actively participate, that was the proposed action, in scheduling proceedings, and advocates should diligently prepare on behalf of their clients. By doing so, they can facilitate efficient case management and contribute to a smoother legal process. The action was both the bar and the bench action persons. Number 3 was judicial independence. Impartiality and integrity are crucial pillars of a fair legal system. Unfortunately, state interference can undermine these principles. For instance, when letters from high-ranking officials such as the president and vice president influence the judiciary, it raises concerns about maintaining an independent and impartial legal process. The proposal was the letter issued does not impinge upon the independence of the judiciary. Interactions between heads of different branches of government are commonplace, addressing both general and specific matters as part of their duties. It's natural that concerns may arise periodically on certain issues. There is ongoing engagement among the different heads of government on rule of law and judicial independence. The proposal was continued engagement on improving the public's confidence in the judiciary and specifically continue addressing specific areas of concern, surrounding impartiality and judicial independence, and the institutions are the bar and the bench. Number 4, inconsistencies, contradictions, and quality issues persist within the judicial system. This is amplified by a growing number of contradictory rulings from courts, decisions of poor quality, inconsistent formatting of legal judgments, and a failure to consistently uphold the doctrine of judicial precedent. Concern is there is a pressing need to thoroughly review and reform the entire judicial regime to address the persistent issues of inconsistencies, contradictions, and quality deficiencies. It's crucial to realign the system with the principles of fairness, efficiency, and consistency to ensure justice for all. The proposal was to form a team consisting of quality assurance officers from the judiciary at all levels of the court, the Uganda Law Society, and the Judicial Service Commission. This team will audit judgments at the peer level and provide guidance to judicial officers regarding mistakes and errors. And the action institutions was the judiciary, Uganda Law Society, Judicial Service Commission, and the AG. Number 5 is infrastructure and technology challenges exist. For example, there is inconsistent communication regarding hearings, notices, adjournments, and rulings. That the judiciary continues to engage stakeholders in exploring alternative communication channels, advance communication for absences, and minimizing adjournments. The proposal was that judges to be more proactive in communicating with advocates and litigants and minimize adjournments. And this institution was the bench. Number 6, disobedience of court orders. Some entities disregard court orders while others demand unnecessary certifications and additional proof, even when presented with a valid court order. That was the concern. It has come to our attention that some advocates forge or misuse valid court orders. This not only jeopardizes litigants, but also undermines credibility in the judicial system. The proposal was that there was need for greater engagement with various stakeholders regarding adherence to court orders. Advocates and courts need to restore credibility in the court process and avoid forgery and other underhand practices that cast doubt on such orders. And it's the AG, the bar, and the bench. Those were the 6 concerns raised, and the additional, we have other 7. The adoption of technology and ADR. ECMIS is the future, and it isn't going away. We are continuously improving and addressing system issues, but all advocates should embrace it and learn to use it. And the proposal was, in case one hasn't received training, he should approach the ICT team of the judiciary, and they shall receive adequate training on how to use ECMIS. Law firms should also improve their ICT systems to meet the standards of ECMIS, and the responsible institutions were both the bar and the bench. Number 8, corruption in court is a great concern, and lawyers are also responsible for corrupt practices in court. All stakeholders need to play their part in addressing corruption, and the proposal was to consider decentralization of the inspectorate of courts to help fight the corruption, and the institution is the bar and the bench. Number 9, unprofessional exchanges between the bar and the bench. The spin-off of the bar bench is the Court Users Committee. This committee should examine these cases and make recommendations. And it was proposed that it would be of great importance if members of the bar become active in the Court Users Committee, because it will help push boundaries on how interactions between the bar and the bench take place. And the institution is the judiciary and the bar. Number 10, inadequate preparation by both lawyers and the judges. The concerns most advocates don't adequately prepare for cases, despite the court's directives on scheduling and timelines for filing submissions. Advocates should request hearing dates only when they are fully prepared and have adequately prepared for their client's case. That's the bar on the bench. Number 11, we have limited number of judicial officers and limited resource allocation vis-a-vis the workload. The issue is if the budget is increased, recruiting 20 additional judges could make a significant difference. Additionally, Parliament has agreed to allocate funds for the industrial court. Currently, the industrial court only has 2 judges, and each judge handles a docket of over 1,400 cases with the registration of over 700 cases per annum. The proposal that the Uganda Law Society and the Attorney General should assist in raising the issue of increasing the judicial budget with the increment of 3 additional judges in the industrial court, and cases will be handled within 2 years and 3 months. Uganda Law Society and the Attorney General. On number 12, remuneration of lawyers on state briefs. The action individual or institution was the judiciary. I didn't understand TBD. Number 14, requirements not anchored in law, such as the requirement to deposit land titles in court before people are granted bail, should be reviewed. That was the issue. And if you are not comfortable with the bail terms of any judicial officer, you have the opportunity to appeal it. If you are not comfortable, that was the then proposal that was shared in that regard. Number 15 is the recruitment of judicial officers lacking in qualifications such as competence, integrity, ethics, and grounding in legal principles, procedure, and practice. The Judicial Service Commission faces a challenge in conducting thorough background checks on appointment of judges due to capacity limitation. And the proposal was there is need to strengthen the Judicial Service Commission to effectively fulfill its oversight role over the judiciary, especially considering the increased number of judicial officers. And the action institutions was the AG and the Judicial Service Commission. Ladies and gentlemen, my lords, that was the action matrix that we gathered last meeting, and you can see it actually re-echoes some of the concerns that you have raised. May I request the Chief Registrar to make his...
Thank you so much, Your Worship. I will begin to provide some responses. And I wish to tell the members that in the next meeting, the matrix will have a column for status report. But in that meeting, we were guests, and so these were brought to us, and we have the responses for you. So the first one about revamping ADR and backlog, I'll give you what is happening to address these issues. Some of you are already aware of this, but for the benefit of those who may not be aware. So you're all aware that ADR has been revamped, and for that matter, we now have commissioned court accredited mediators who were commissioned by the Honorable the Chief Justice, and these have been deployed in a number of courts, including all the divisions that are represented here. These mediators consist mainly of retired justices, judges, and other judicial officers. They are working, and one of the highlights of what they have already done was the settlement week that was handled in the first week of August, where we had about 235 cases resolved in 1 week. In addition to that, the registry of ADR has been fully established, and there is a registrar who is running that docket. And this registrar is coordinating and managing ADR countrywide. We are in the process of training, commissioning, and deploying other mediators who are around the country outside the initial pilot courts. And the registrar here has already a roadmap to go out, train some of those mediators who are previously mediating in the courts, have them properly accredited, and they continue doing ADR, particularly mediation in the courts. Related to that, remuneration of mediators was streamlined. And for those who are mediators, you have seen that office instruction by the Chief Justice, which brought an end to the complaints of unpaid mediators or where mediators were alleged to be demanding for payment from parties. And therefore, the issue of remuneration has been streamlined, and mediators are now well attracted to work and perform the mediation. Additionally, the mediation rules of 2013 are undergoing review by a subcommittee of the Law Reform Committee of the Judiciary, together with the development of rules for appellate mediation. All this is happening intended to streamline and further revamp ADR. The Alternative Justice Strategy, a draft is in place, and for those who attended the Family Justice Summit, you had the highlights of what is in it. And the next action point is to complete the development of this strategy, have it launched, piloted, and eventually rolled out. So everything to do with ADR as a strategy for reducing backlog is on course. Next to that is the issue of the operationalization of the case management committee that I had talked about. That committee, if you look at its functions, one of the key ones is to study the challenges to effective delivery of justice and advise on appropriate strategies to address the challenges and be able to conduct research and come up with proposals for ADR, for case backlog clearance and case management in the judiciary. Now, quickly, to just tell you what is on the roadmap or the work plan of that committee. One of the things it hopes to do before end of the year is to conduct a case census. This census is going to allow us to know exactly what is our caseload in the judiciary generally. As we do that, we are going to also do the case data cleaning exercise so that we have our records in our systems, ICMIS and CAS, tallying with the physical files that we have. We believe that once we know the actuals, that is going to help us really in planning and putting our energies where we need to do it the most. Under that committee, again, we are reviewing the case backlog reduction strategy of 2017. We know that there were many strategies that were proposed. Some have been implemented. We want to know the extent of implementation. And one of the key highlights in that review is the issue of enhancement of jurisdiction of magistrates' courts, so that we can offload the High Court and bring a bit of more cases down. I wish to inform you that the Honorable Attorney General's representative here may comment further, but the judiciary finished to deliver the report with the proposals on the extent in terms of amounts of this pecuniary jurisdiction for purposes of the necessary cabinet memos and the amendment of the Magistrates Court Act. In our proposal, going by the figures we have in there, if it is approved, then we shall have High Court offloaded of about 60% of the cases. Now, if you have 60% of the cases coming to the magistrates' courts, then you're going to have judges going to focus on manageable workloads, and I believe this will resolve some of the other problems that you have been raising. Relatedly, what we are also doing in this committee is unpacking our judicial processes in terms of our steps. Do we know how many steps we go through in a judicial process? For example, you file your matter in a magistrate's court and you run on with appeal up to the Court of Appeal. How many steps have you gone through? We are benchmarking lessons from Tanzania, where they managed to unpack their judicial processes and then see what to cut out. We were amazed to see that in some cases, they reduced from say 700 steps to 300. So those are things we are doing. In the end, it is going to help address the issue of backlog. And then how about the issue of training? Case management also requires some level of training. I think Council Anne, you were talking about this issue. We are in advanced processes of having a comprehensive curriculum for judicial officers and relatedly preparing a training calendar so that every judicial officer can go through a thorough training on case management, judgment writing, name it, all the different areas that are needed. As I wrap up that area, I just wish to inform you that PJ and I and others had a benchmarking visit in Tanzania where we saw an ideal training institute where magistrates are trained for 3 months after recruitment. You go through an induction of 3 months to become a judicial officer and then go out there. What do our resources allow us to do? 2 weeks if you're lucky. So to compare a 3 months inducted magistrate and a 2 weeks one, of which 2 weeks is even better. We've come from the days of 1 week induction. We have come from the days of you spend 2 years and then you are inducted. So certainly, sometimes we have to learn by some mistakes on the job and keep getting better. And I think that is really an approach that we have to take in a practical way. So my Lord PJ, that is the highlight of the responses in relation to issue number 1 about backlog and case management. The plans are many and others we shall continue to share as they come along. If we can just proceed, Your Worship Eremia, we are going to just proceed. I don't know if I can proceed to the other, or my Lord, maybe you want to add more on that, or we run through the entire matrix. Let's run through, okay. All right. Okay.
Yeah, my worship, after running through the matrix, then we shall allow the President ULS also to make their comments and the AG.
We have the heads also of division. So the heads will be making some specific
the principal judge.
So the second was about the judicial process inefficiencies, and here it was really a call to advocates and judicial officers to be prepared. And the response there is that this was for each judicial officer and each advocate to do their part. The third one is about judicial independence and impartiality, integrity, the continued engagement between the bar, continued engagement on improving public confidence in the judiciary, and addressing specific issues of concern surrounding impartiality and judicial independence. This one, as a general comment, I'll say engagements have continued to happen, and my Lord PJ or their lordships will say more to this matter. Number 3 is about these inconsistencies and the proposal to form a team from the different agencies, institutions there. The update I wish to give members is that we already have a concept developed for the creation of a judgment review committee. This concept is still being further polished, and the catchment area that we are looking at to form this committee are the pool of retired justices and judges and some of the chief magistrates and the like. Those are the people we are looking at who will form part of that committee, who will be able to review the different judgments at different levels. So this one is continuing to happen. Number 5, infrastructure, technology, issue of inconsistent communication regarding hearing dates. Proposal here was judges should be more proactive. I want to believe that many courts have become really proactive. And I think, my Lord PJ, on this particular issue, I would be happy to receive specific complaints, because I've had meetings with the registrars who manage the divisions and the superior courts. I have had meetings with chief magistrates, with magistrates in charge of the courts, and it's a requirement for everybody as a minimum, for instance, for starters, to have a WhatsApp group. If you're not there next week, communicate it on that group. So as a minimum, that one is expected. It is expected that as a minimum, you put out a notice. But we've also told all our officers that ensure in the registry, as matters are being filed, contacts are being left behind, because we have gone across the country almost everywhere. We know the kilometers people travel to access justice. So this should be happening. If it is not happening in a specific court, just let us know, because we can't repeat it in a blanket, because we know these WhatsApp forums are there, they should be utilized. Phone contacts are there, there should be some small money for somebody, a clerk, to be able to call a litigant and say, please don't come. We've even told them to put numbers of LCs where a peasant, for example, has no phone number, but some way of communication. So let us have specific courts where this communication is not happening. And lastly on this, if you look at our inspection tool, the one we go to inspect with, one of the parameters there is the issue of communication to litigants and advocates. So we expect to tick that box with everyone in whose court we visit or we inspect. Number 6, disobedience of lawful orders, of court orders, need for greater engagement, AG, bar, and advocates. Advocates need to restore credibility and avoid forgery, underhand methods. I think advocates, this is to you, Law Society, and AG, you will say something. Technology, ICMIS, law firms should be trained. I want to report, my Lord PJ, that every law firm that has written to me requesting for their members to be trained, at least we have sent our people there to train them. So in case there are those who haven't, please just let us know and you will receive your training on ICMIS. And I wish to inform members that in this financial year, we are rolling out ICMIS in 18 courts. That is in addition to the current courts. And so the ginger that was being talked about is on schedule. We have Entebbe, we have Nabweru, Chira Court, Machindie, Family Division, Buganda Road, Standards, LDC, among others. We have 18 courts that will be live on ICMIS by the end of this financial year. Corruption in courts, consider decentralization of the inspectorate. This one, the Honorable PJ already talked about it. It's a work in progress. I just wish to add that we have a vibrant disciplinary committee chaired by the Lady Justice Percy Tuhaise, Justice of the Supreme Court. It is working. We also have an integrity committee chaired by the Lady Justice Monica Mugenyi of the Supreme Court. These committees are all intended to address and help fight the issue of corruption and failure to adhere to the code of conduct. Peer committees have also been captured clearly in the inspectorate regulations, and very soon they will be appointed at all levels of judicial officers as a soft tool to help members deal with such issues as unethical practices and the like. So there is work being done. Corruption, I'll tie it with the laziness that was talked about somewhere. I wish to inform, I think, Council Mutavingwa, that we have somebody interdicted for laziness who for a whole year did not deliver any judgment. So if you're a judicial officer and 1 year down the road, no judgment, surely. So laziness is not being rewarded, it is being dealt with. So you bring up all the others that perhaps you may be knowing behind there. Unprofessional exchange, greater if members of the bar become active in their committees. In my welcome remarks, I talked about all these committees, and my Lord PJ, I wish to also inform you that all divisions have set up their user committees. They sent me the membership, the circuits have them, they are chaired by their lordships here, and all heads of circuits. In the magistrates' courts, also about 80% of the operational magisterial areas, we have these meetings happening. In fact, for the acting chief magistrates, one of their key performance indicators was the convening of DCC meetings. So we are strict on these meetings. It is just that the advocates pay interest and attend them when invited. Number 10, unpreparedness. Advocates should request hearing dates only when they are full. I think this one is for both advocates and judges to prepare for the matters before them. Limited number of judicial officers, advocating for resources. Just to report that we have not reached there, but we have a sizable number of judicial officers right now. We have 657 judicial officers. The lower bench particularly has quite a number. Recruitments are happening. We expect to have another, for instance, 12 chief magistrates. If we get them, we shall have 103 chief magistrates. I believe 103 chief magistrates can take us far. If we have the set of judges recruited, about 16 of them, it will be taking us to about 95. That is close to 100 judges. We've not sampled them in this country. For long, we've been having few judicial officers, so we are making progress. If we get the 7 justices of the Court of Appeal, we'll be having 20 of them. So that should be able to take us far with what we are doing. But of course, we continue to welcome every additional budget support that we can receive. Remuneration of advocates on state brief. We have the state brief rules and it provides the different ranges. My Lord PJ, I wish to inform members that sometimes members have not been paid what is in those rules because of budget issues. But right now there is the state brief implementation committee that I chair. We are currently conducting an M&E on this issue of state brief, including the remuneration and the quality of legal representation. Once that report is ready, it will also be shared. Number 14, this is requirements not anchored in the law. This one, I think the answer was already given there, that where these requirements come, you have options. Number 15, about recruitment of people lacking in qualifications, my Lord, that was not for the judiciary, it was AG and JSC. Thank you, my Lord.
My Lord, allow me invite a representative of ULS to come and make responses. Thank you.
Thank you very much, my Lord. On behalf of the Uganda Law Society, I simply want to say that we have heard and listened to the advice, to the criticisms, and to the encouragement, especially in the areas of professionalism, mutual respect, and collegiality. I know, as my brother, Mr. Milton Ochen, noted, that there's some black sheep of the family. But I want to ask all of us to be encouraged. We are not all like that. And we have learned, we have heard the concerns, especially as regards our conduct. I have been thinking, my Lord, I don't know why this did not come way earlier. I think we badly need a similar engagement with the Law Council. We need to sit in one room with the Law Council and the advocates so that we can each raise our concerns and be reminded of the rules of the game in which we operate as members of this profession. Issues concerning the cases that we file, the type of work that we do, the quality of the work that we do have all been taken in good faith, and we're going to work on them. I'd like to believe that it will be the same for the judiciary. Your Worship, the Chief Registrar, I'm grateful for the Secretariat and the matrix that they have come up with. I'm hoping that this time we'll get it a bit earlier so that we can be able to have our input on the responses that we have been able to make, on the tracks that we have made, on the promises we make, and also be able to respond to these issues, especially by consulting the membership and continuing to take their views. That is all I can say in response to the issues concerning Law Society. Thank you.
Thank you very much for those responses. And my Lord, allow me, and you may stay where you are as you respond.
Thank you so much. I'll only respond on the one to do with the respect of court orders. I like to say that the Honorable Attorney General did write a circular to all accounting office and all accounting officers and all responsible officers in respect of court orders to always comply with court orders. So to that extent, he did discharge his duties. Thank you.
Thank you very much for that response. And this juncture, I invite the Honorable PJ. My Lord, you may still also use that microphone if you may.
Okay, thank you so much. I know a number of issues were raised. I think Anichira raised an issue of failure to recruit judges. I think we are doing well. I've told you we are going to recruit 10 additional judges. And then there will be 16 in number, but the 6 are replacements. So, but the additional ones will be 10. So we have 2 judges who were appointed to the Court of Appeal. We have 2 who have retired. And then we have another extra 2 who are going to retire in the coming 2 months. So so the others will be replacements, but also so in essence, because you remember we increased our number to 150. So meaning that if we can get, even if it is every 2 years, if we can get an additional 10, I think soon we shall be there. That is my belief. Then continuous training of officers at the lower bench. I think my sister here has explained well what we are doing. Maybe I can only add that when we left Tanzania, we engaged the district of Nakasongola and they gave us 20 acres of land. We have already fenced. We actually, no, we haven't, but we are beginning to fence the land. So we are going to construct a state-of-the-art residential as well as a training conference facility, which then can help us to train our judicial officers for, let's say, a month or 2. What has been happening today is that we bring judicial officers and take them in a hotel, and we do not have enough resources given the budgetary constraints. So we used to train them actually for 3 days. Now we have improved it to 2 weeks. But as you know, if you have recruited a lawyer, maybe who has been two years in practice, if he has not been in a business law firm, he might actually not have even appeared in a court of law, or he could have appeared there only to adjourn. So now you bring him on board as a grade 1. So you need a lot of training, bring lawyers, bring senior lawyers, bring judicial officers to grill them into the nitty-gritty of practice, but as well as judicial work. So so we hope that is going to, of course, that is long term. In the immediate term, we shall try to look at the resources and see whether we can increase, maybe it's 3 weeks as we wait for this. But this is priority, so we shall prioritize it and make sure that we train both. And another advantage, of course, is that when we take judges there, they are not going to come and attend to their families. We shall have them in that space for you can't just step out, say, let me go and check on the family and come back, because it will be very difficult to go through the jam of Matuga and then to come and see the family. Then judicial officers are not studying the files. I think that was one of the issues that was raised last time. But obviously, if you go to court without studying the file, you can't be on top of the game. That is clear. So maybe this is a training need. Otherwise, because you must know, you must even predict what the lawyers are going to say. Because you have studied the file, you have looked at the exhibits, you should be able to raise issues with the advocates as they are representing their clients. Now, a judge in Ruero, I'm telling you that because we have that deficit already of 4 judges who have retired, I've tried actually to poach in some more. For example, there is no judge in Mubende. I had requested the one in Chiboga to sack it there 2 days. It has become increasingly difficult to receive complaints. So I have snatched one judge. Now I must inform you, my lords, that I've poked into your divisions. I've picked there one judge not replaceable until I get new judges. So that will maybe create issues, but you will bear with me because there are courts which are empty. I snatched one from civil division, sent him to Soroti to replace Justice Adonio, who is leaving next week. I have also snatched one from the commercial court. I have not told you, my lord, but you will see it, of course, from Mubende. So these are you'll bear with me. I know the challenge there as well. It's painful to remove it, but these are interim measures. Now, the judge in Ruero is retiring in March next year. So that means that we need a judge to be there. Most likely she's trying to finish the judgments. So I need a judge to go there. But as you have seen, I still have a constraint. But maybe I will also look at it because I've now poached from civil, commercial. Now maybe my Lord John and 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 Tadeo, you'll bear with me if I also visit yours, at least for one judicial officer. So maybe to kind of like to go to Ruwero, because I can understand the dynamics. It must be very difficult to appear in that court and then you are given an adjournment of a year. It's very discouraging, at least for some of us who have been in legal practice. Now, calling lawyers thieves, I think I know you. I think one of you was contesting what Mutavingwa said. I don't think Mutavingwa said that all lawyers are thieves. He mentioned that there are lawyers who are thieves, which is true anyway, because we don't have to hide these things. But what he was trying to say is that now I remember at one time during the Jimara's regime, you introduced something called bury the cat. What happened? Did you fail to get a strong rat to go with the bear and because we waited for that? It was a very good program. So I waited. I said, let me see how these lawyers will bury the cat. Or the cats have, been loitering in the compound, and lawyers are running around with their bears as if they want to bury each other. Anyway, then public confidence, I think arbitration. Now, we have been thinking in this is an idea we have been conceiving in law reform. For example, in Nigeria, they can even do what we call forced arbitration because they introduced that in their rules. I don't know whether that's the way we want to go, but since you have a lawyer, represented on our law reform, maybe you need to give us ideas. What reforms can we do in this area? And the moment, maybe you discuss amongst yourselves and give us ideas. Which ideas then we can implement in law reform? I have members here of law reform. John is here, Sekana is here, Sarah is here. So we are open to all these ideas. Help us to understand what we can do. Especially, I'm concerned that we have not created a credible arbitration center here in Uganda that people must go and arbitrate in London. There is a lot of money that would come as a result of an arbitration center here that is credible. So I think as lawyers, we need to take that heads on. How do we, I know you had tried to create an arbitration center. I think some lawyers tried. I think the Jimaras were kind of like spearheading it. So I don't know how far they went, but that's an area we must deal with. So that, I know there is the SEDA. The last time I had a meeting with my Lord Mubiru, I was asking, anyway, I think there are so many issues with the SEDA, which maybe I think in your user committees, maybe you can address them. I don't know. Okay, I think he's giving him information that is being rationalized. Because I think I have a lot of concerns which I'm not going to share here. I'd share them with the head of commercial division. Then I think Laston, can we for matters? I think when you look at the new civil procedure rules, actually the purpose of introducing summons for directions was supposed to help judicial officers identify this need early enough. So that if you think that these are matters that can easily be sorted out by ADR, then you refer them. So I wonder why we are finding this as a difficulty, but it's an area where we can really, maybe it's a training need which we are going to, since the CR is here, we can deal with it. Now, interim application not given at the Court of Appeal, I think I will discuss this with the DCJ, but I know the Court of Appeal, they have more than 7,000 cases. Now, if you notice, while at the lower level, a judge sits alone, at the Court of Appeal, they sit when they are 3 or 5, depending on whether it is a constitutional matter. So if you get 7,000 cases and divide them by, so you get 3 judges, that's one panel, that means one case. And if you divide, now if they are 15, and remember recently they have not been full. I think even as we talk, I think there are two who went to the Supreme Court. So they cannot even raise, if it's a constitutional matter, they can't raise 3 constitutional panels. They can only raise 2. So you divide all of that, those 7,000 by that number. Maybe let's say you divide them by 4. If I can say, maybe if they can form 4 panels. So if you divide it by 4, then you know what each panel has as a burden. That's why we are trying to increase the numbers there as well. And as I've told you, we are recruiting 5 for this quarter. Then, of course, provocation. Someone said, why do you provoke us? I think maybe I have no answer. Now, the industrial court, of course, you have seen the figures in the industrial court. We are trying to streamline the industrial court. And I think the discussion we have had with an organization called Enabel, we want to have the industrial court we are looking at different models. There is the Kenyan model, there is the South African model, there is the Ghana model. So we want to extract the industrial court from Ministry of Labor for the simple reason that there it's not a priority, because when they are looking at the matters, as a ministry, I think the industrial court is subsidiary. So we want to have it either as a division of the High Court or as a standalone with an appellate process. In which case, then we can easily staff the industrial court. And this will be done soon. I don't think we shall go beyond next year before we streamline and have the amendments. The amendments are before the Attorney General, but we agreed that we hold them until we look at those structures and be able to restructure. So I think that in the interim, it might not be as we want, but I'm sure within the next 2 years, we should have streamlined so that then your matters can move quickly. Remuneration of lawyers and certificate, I think that one, it has been answered. Those are the few I remember that were raised. I don't think there is anything. Oh, no. There were those which were raised by Mutabingwa. I think there were lawyers asking money in the names of the judges. That is very unfortunate. I remember one time when I had left Masaka, I left there John. Then one lawyer asked clients that they should give him 5 million to be given to me. So he had, I think he had looked at his matter. It was a matter where someone had pleaded guilty for cutting someone's banana plantation. So they filed a civil matter. But so in other words, he knew that since there was a plea of guilt, the other civil matter would be very easy. So he asked for 5 million in my name to be given to me. So unfortunately, when I brought the judgment, it had been barred by limitation because they had filed it after 7 years. So I had dismissed the case. So when the case was dismissed, they started looking at each other. But we gave this fellow, this man is a thug. I'm sure they were thinking I'm a thug. So I think subsequently they contacted one of the lawyers because the lawyer told me, I think that was Johnny Kawanga. Then Johnny Kawanga told them, no, that judge cannot take a bribe. I know him. So what you do, go to the judge. Of course, apparently they did not tell you that they were sent by Kawanga, but he's the one who sent them. So when they came, John brought the lawyer and said, counsel, stay here. These are the fellows. You picked money from them. I'm taking you to prison unless you refund it. He started saying, no, that was my legal fees. He insisted. And the lawyer brought it. And that was it. It was solved. But you can imagine that embarrassment. For me, I'm there doing my job. Kumbe, I'm a thief in the eyes of the litigants. Can you imagine? I think that's very dangerous, colleagues. I think that if that is established amongst yourselves, I think you should have your own tribe, of dealing with such fellows, because it discredits the judicial system. Then judges who are thugs, I think he also mentioned judges who are thugs. I mean, if really judicial officers, if you know you are a thug, surely you are in the wrong place. How can you be a judicial officer at the same time you are a thug? Then he talked of bail in magistrate courts being, being obtained by. I really think, comrades, if you can give us that information, it would help us. And this is what I find strange, that you complain against the judicial officers, but you don't have the courtesy of just coming, secretary to us and say, this fellow here is a common thief. We would take action. Where the information has come to us, we have interdicted them. And then the Court of Judgments, do we ever, apparently when we may not be publicizing these things, but every time a judgment comes out of that nature, we really don't leave it at that. We summon the judicial officer and try to understand what the problems are. Is it a training need? Is it incompetence? So they go through a lot. If we don't leave them. No, we do summon them. So we may not be giving you feedback, but actually we take action. And of course, we normally tell them that if this is repeated, then I think the next course of action should be escalation. It means that you are not fit to be a judicial officer. Now, the premises in the family division, I thought actually we had improved. I'm surprised. The former premises were like cubicles, where lawyers wouldn't even have space. Now, I know we are, maybe for information, we are going to construct divisions at Naguru, and it is one of the projects we are going to start on this financial year. So all divisions will be housed at Naguru. We would have started this quarter, but there was no release for capital expenditure. We hope this quarter capital expenditure, when they release because that place we had brought it, sorry, we had acquired it for ACD and ICD. But then we discovered that family division was also in a very, very difficult situation. So that's how we brought them here. I know the congestion is there, but we shall solve it going forward, I think. Rosara grade 1 court, I think we are going to follow it up. We need to go there. At one time, actually, they were in a court where at one time a snake fell and they landed on the table of the judicial officer. That is an improved version, sir. So yes. So that's an improved version. We had an old premise. So now you can see we are improving. So we are going to look at it. At least now there is no snake. So the next one definitely will be better than the current one. Chandia, okay, feedback. I think you have noticed that we are taking action. And as we have said, next time we shall have a quorum of what we have done. And I think I agree with you. We shall share with you this matrix. So that if you have also your input on your side, then you can put it in. Social media, Chandia, this is an emotive area. In fact, there is a whole lot of literature now on how courts and the different jurisdictions are handling it. Maybe it's an area where we need some legislation in the form of either practice direction or something, but it's something you can also give us ideas on what you think should be done, and then we can also, from our side, bring ideas, and then since we sit in law reform, we can handle that. Raw morale of work because of being in one position for long, what is the criteria for promotion? Now, of course, as you know, Judicial Service Commission is a separate entity from us. Yes, we have representation there by one judge, but the rest are either, but you also have representation there of two lawyers. So whatever mistakes, we share them. In fact, you share them more than us, because for us, we have one representative. For you have two. So now, but I must tell you, Chandia, that sometimes some judicial officers, like the ones you have been talking about, someone does not write judgments, and he's ever in, disciplinary and then back. How do we then promote him? you'll find the fare will remain at the same level for long, because you visit an area, you find he's not at the station. So, I mean, and he becomes or he or she becomes a consistent problem. Of course, ordinarily we should exit them, and maybe that is what we are working on, because we did not have a performance management tool, which now we are testing. That performance management tool will have a traffic light system. So if you fall in certain category and you have not performed, we get rid of you, because at the moment we didn't have it. So sometimes, you know, since we are legalistic, sometimes you say, if I exit him, what will be the basis for my action? Okay, assigning judges to particular divisions who are not competent in those areas. Now, I must tell you that when these judges are recruited, they are recruited to do everything. Now, personally, I have no difference between divisions and circuits. I believe they are all the same. They deserve better, all of them. So when I'm deploying judges, I do not say, this is a division, let me deploy so and so. I deploy generally. Now I know, because if you say those who have been, let's say, doing criminal, assuming, let's say, state attorneys, those who have been state attorneys, I should put them in criminal division. So if they are 20, I will put 20 judges in criminal division. What we need is just train these judges. I know, for example, for practicing advocates, you will find maybe people may be, let's say, Council Kabega may be in the criminal area. Maybe that's where he has a lot of competence, but he will still handle civil matters. Yes. So what I'm trying to show you is that what we need is just induction, and then judges must read. Read. If you don't understand an area, read. Yeah, because I mean, we all join the judiciary, for example, when we have never handled criminal matters as judges, we want to handle them as lawyers. So, but now you are there taking plea. So what do you do? Okay, so I think, Chandia, you understand my perspective about that. Now, daily judgments, what we are doing is that we are tracking them, and when we go, maybe to inform you that we have a quarterly performance review. So in that quarterly performance, it's normally residential. We look at what business you have, what judgments are pending before you, your backlog, and why. So it's really a grading kind of session. So we hope that this tracking, because by the time we come for that meeting, I already know. Actually, off head now, if you ask me how many cases are pending before just so and so, I will tell you, because I track them, I know them. So we think that maybe with the performance improvement tool, we should be able to hold people accountable for delays in these judgments. What is the solution to multiple filings? I've told you we need, I'm mooting an idea that we should have some practice direction or some regulations where we start punishing such fellows. I know lawyers fear costs. If there is any person who fears costs personally, is a lawyer. We may have to look in that direction. If you are filing multiple matters, when they are consolidated before one judge, the judge at the end of the day should order you to pay costs personally for the multiple filings you did in other places. That is how we shall solve that problem. Mandatory bail applications, I know we have been having issues in this area, especially the transition of files from the magistrate courts to the High Court. And I think it has been brought to the attention of law reform. We are trying to find a solution on how we can solve that. So sooner than later, you will find out what the law reform is doing. So those were the issues I think you raised, which I can respond to. And in conclusion, I must thank you so much for coming. Don't get tired. We must engage. It's our responsibility as lawyers and judges and judicial officers to engage, because we want to sit on different sides of the coin, but we are the same. We are all lawyers in the first place. And what pains you should also pain us, and vice versa. Thank you so much.
Thank you very much, my Lord Principal Judge. Let us give another applause to the Honorable Principal Judge. Let us also give an applause to the representative of the Attorney General for being here with us. Another hand clap for the Chief Registrar for those responses and enlightening us about the interventions, and also another applause for the Vice President representing the President, Uganda Law Society. My Lord, the PJ, we want to thank you for the time that you have given us. And we want also to thank the Lords. I don't know whether at this moment they had anything to add. They said they have nothing useful to add. Okay. As we have a cup of tea, which is going to be served at both the 7th floor on my left, and also we shall have another group which can go on the 60th floor. My Lord, I will request that we have a group photo, which we are going to take right here. And may I request the teams to come and help us, and we have the necessary seats. Okay. So Sheila and Tim. Yes. So we shall have, yes, let us add for the judges, and the rest of us, we shall stand behind. We can have 9 chairs. Let us have 9 chairs. My Lord, I might be sued for making a false statement. Okay. So I will request the Honorable Principal Judge to take the seat. The representative of the Attorney General, the Chief Registrar, the judges present, and let us have this photo. Attorney General, please. The judges, let us sit. Advocates present, please let us have this this photo. Let us have this photo. Two. Let us have 2 more chairs. Two more chairs. President, representative, and okay. Okay. So let us have this wonderful picture. Oh, we can fit in this picture, please. Let us have this picture. Thank you very much. Yes, let us have the cup of tea. It's available for us. My lords, on the 7th floor, we have a cup of tea.